We are recording. You ready, Jinie?
Yep, awesome.
Okay, let's do it. Hi, everyone. I'm Kristin Leong. I am the founder and executive editor of the Family Court Report. And welcome. This is our first ever behind-the-scenes conversation with the Family Court Report's inaugural Reporting Fellow, Jinie Chon. Jinie, welcome. It's excellent to be here with you today.
Thank you so much, Kristin. I'm so excited to be here as well.
Jinie is a second-year honors student at the University of Washington. She's double majoring in law and philosophy with a specialization in ethics. Jinie is also currently an intern with the Washington State Human Rights Commissioner, a council member with the University of Washington's College of Arts and Science Dean Advisory Board, and a citizenship practice interviewer for first-generation immigrants with Literary Source. Jinie, for the Family Court Report, you have been reporting on the rights of youth in family court. Now, I want to start just by clarifying some basics for viewers who may not be familiar with how the family court system works. Let's talk about the roles parents, children, and court professionals play in usual custody cases. In family court, when custody is being decided for children, this can include when things like which parent a child will live with, which parent has decision-making responsibility for things like education and healthcare, what that child's visitation schedule would be with the non-residential parent. Parents, or the lawyers of parents, oftentimes, are really in the spotlight, and then they are followed closely by court professionals and experts like parent evaluators and pediatricians and teachers and agencies like Child Protective Services. Way at the bottom of that list are children themselves. And in fact, in many states, youth under 18 are not allowed to participate or even be informed about any family court proceedings. Jinie, why does it matter that children at the center of custody cases can't be heard in court or be a part of this process?
Yeah, I think it's so important because we often talk about, promoting youth voice or, uplifting children, teaching children to advocate for themselves. And I think truly, if we want to have that conversation of asking children to advocate for themselves, we really need to have, the legal resources and also just the legal space to have the opportunity to talk about their experiences. I don't think it's a question of, pick a favorite parent. Children have a lot of experiences, lived experiences. I think it's really important for them to be heard because, there can be cases of abuse or neglect and, cases of safety or even life and death. And parents can argue about custody, but also at the end of the day, I think it's the children that are actually going back and forth between parents. So it's really important for them, for their voices to be at the forefront.
I mean, in a lot of these cases, it's the kids who are the only people with firsthand knowledge of what's really going on in the homes besides the parents themselves who are maybe disagreeing in court. Jinie, it seems to me that in the US, before this work, I was a middle school teacher, and I reckoned a lot with advocating for young people's voices to be heard as an educator. But it seems like in the US, we are very confused about what teenagers are capable of and can be responsible for. Jinie, in your reporting, you've been researching legal age laws across the United States and comparing your findings to the rights of youth in family court. What kind of mismatches or surprises have you been finding?
I think truly we have such a different standard. Even if we're talking about the same kid, we have a different standard for like whether they can work or, whether they can be emancipated or whether they can have medical treatment or whether they can go to family court. And, it's across the states. I've seen, for example, in Florida, it's I believe the age of emancipation is around 16, and you can get medical treatment for a sexually transmitted disease without a parent present. Driver's licenses around 15, 16 with a permit. And, a lot of child labor laws start around 14. And so I've seen that, even though it's a case that even a child can be working at 14, have a driver's license at 15 or 16, it's not common for their voices to be heard in the court system. And so I think that's really concerning. There was a from the law, it says, is the child's voice necessary and relevant? And those kind of disconnects, I think, really highlights, the mismatches that I found. You can say maybe it's the political environment in Florida or certain states, but I don't think that's the case, because California, which is considered the fifth most democratic state, has a similar pattern. Emancipation is around 14, driver's license around 16, minimum age 14. But when they're in court, it says generally 14 or older. And it's, as we mentioned, it's kind of like the last resort. Even if they're 14 and older, it's not really the case that they're heard. And so I think it's really important for us to recognize those kind of disconnects. A child can be driving, but not necessarily in family court.
That's interesting, Jinie. So what I'm hearing from you is that this is not a blue or a red state issue, that you have seen across the United States a sort of muzzling of children in the justice system, even in our very liberal states like California, even in states in Florida where children can be emancipated as teenagers, still yet in family court, their voices are not supported. I saw that firsthand here in Washington state. Of course, we're a very, very blue state. And yet the medical consent age here is actually 13. This was a shock to me as a mom. When my son turned 13, I was informed that he could start having, private and confidential meetings with his healthcare providers. But then also he, as a teenager, as a 13-year-old, had to actually sign away consent for me to even have access to his records. And yet in our family courts here in Washington state, it is flat out not allowed for children, any child under the age of 18, to testify in family court custody hearings, to submit a declaration. They are not allowed even to be present in the courtroom when these cases are decided, that are deciding, where these children live, who they lived with, what their day-to-day, week-to-week life will look like. And they're not even allowed to be in the courtroom. And that even translates to criminal courts here in Washington state. So in the case of a domestic violence protection order filed on behalf of a child, if that alleged domestic violence is from one of the parents, and that child their parents have an active family court case, even though in criminal court, youth are supposed to be able to testify for themselves in the cases of violence, if there's a family court case active, they are strongly, strongly, strongly discouraged from participating in that process at all. Jinie, I want to go back to Florida. You mentioned Florida earlier. You uncovered a very interesting case there involving a 10-year-old girl whose testimony could have been very helpful in a neglect case involving her father. What can you tell us about there?
Yeah, so I would say there is an attorney, Williams D. Slicker. He wrote an article in the Florida Bar Journal, and he covered this case where he was working with the 10-year-old girl and her family. And legally, the child was under the custody of the father, but really wanted to seek refuge with the mother. The father was using substances. There was rarely any food in the house, and she felt really unsafe under the protection of the father. But the judge ultimately denied any motion, actually declaring her testimony as nothing more than hearsay. But they did have police officers who witnessed the father using these substances or being abusive. And so just the fact that, there are a lot of cases that aren't observed by the police. And so I feel like these are one of the cases, what if there was no police and the child's testimony was really just all hearsay, and it's not really credible at all. And this is an older report from the late 1990s, but I will say this is still very much the case, and youth testimony is still considered hearsay. And the judge strongly prefers police or just the parents being involved, not really the child.
What's striking to me about that, Jinie, is that the police testimony was really valuable for that child in that case, but it's not as if the police have required training across the country on domestic violence or child neglect. And so we're really relying on the testimony of others who may or may not understand what it's like for these children. And meanwhile, the one person, in this case, this 10-year-old girl who was trying to speak up for herself about what was actually happening at her father's house, wasn't able to be heard. Jinie, just to back up for a second for folks who may not be legal scholars, how would you define hearsay? If you said the judge just dismissed the child's testimony as hearsay.
Right. So hearsay, is a form of, saying, oh, another person said this in court, but that person is not present in court. And, this is often used in criminal court, but an example would be where like a person A told someone else, person B this, and person B told person C this, and therefore person C brings this to court. And because the original person is not there to be quoted, the attorney or judge can actually object and say, that's hearsay and we can't really go off of that information. And that's kind of ironic, to be honest, because the child is in court if you let her or let them or let him be in court. And so I think it's really ironic because you're saying that like the child's not in court and therefore you can't use what they're saying, but they're willing to be in court and you're not allowing them to, say. So I would say like that's a really problematic way of, characterizing a testimony, because you're almost saying that, I would say like you're characterizing like the child who is a victim of the situation as saying, oh, your voice or your experience is not really relevant in the situation and you don't know what's best for yourself. And so I think it's almost dehumanizing to say it's just hearsay, but I would say that's kind of the context, especially in the family court system.
And what we're hearing from kids, especially older teenagers, is that they want to be heard and that they want to be able to participate. They want to be able to submit testimony, that they want to be able to speak up for themselves. And so saying that, oh, that can't be counted because the child's not in court, a lot of these older kids are prepared and more than willing to do that. Now, let's move one state north of Florida for a moment. Let's talk about Georgia. Georgia is, in fact, the only state in the United States that explicitly states that youth 14 and over have the right to choose which parent they want to live with. That sounds like the voices of teens are really respected under that law. But in your reporting, you found that that's not quite so simple. What's happening in Georgia?
Right. So it says technically it's like a right, quote unquote, right for children to testify, but you see that it's not really the culture. At 11, youth can write a written submission. And, in reality, it's really hard even to submit a written submission. And even if the judge will consider it, it's even hard for a child to come out with allegations against their parents, even if it's like a trusting person like their teacher or counselor. But the fact that, they're just alone in a chamber with their judge and their lawyer is just very, how do you expect a child to be comfortable to then testify, even though I think it's a good step in the direction of allowing children to voice if you consider a right. But I think we really have to create an environment where children are encouraged to testify instead of saying, oh, we don't really need your voice. I think you really need to encourage children. And so I think the written law and the practice of the law really go hand in hand, as in any situation, but especially this one.
So I'm hearing from you about that that could be quite intimidating for a child to meet one-on-one with a judge in their chambers without their a parent present who they trust. Are there other barriers? I'm hearing from you that it's hard for kids to submit written statements. Are there like bureaucratic challenges? What's preventing kids from being able to sort of enact that law that says that starting at 14 that they're able to choose which parent to live with?
Even though children want to testify, they might not necessarily be comfortable in doing that, especially if it's a case surrounding their family dynamic, or if they're trying to testify against someone that they love or trust. Also, another thing is it has very vague wording. It talks about if the judge deems the child phrases like whatever is in the best interest for the child, even if the child testifies, that's just one part of the larger thing. And if the child doesn't seem like, they know what they're talking about, or whether they're like intelligent enough. Even if they do step forward, there isn't a big difference. And so that, discourages children from testifying. I think the fact that, the court system kind of places more weight on the opinion of a judge who isn't actually in that home dynamic than the child themselves, I think could be another big deterrent from not only testifying, but also feeling like, because feeling like you have that right. I mean, the law could call it a right, but unless you can actually practice it, it's not really a protected right. It's not like freedom of speech where you can, I guess, even in this situation, it's not like freedom of speech where it's like you could say something and it's protected. It's more of, it's like a silent stifling of the children's voices. Just because of the culture surrounding it, the vague wording surrounding it. And so I think it's a big compendium of different things.
And still yet, it seems like compared to other states, especially here in Washington, it sounds like Georgia is the most progressive. Actually, it sounds like other states could use those laws as a model to follow if we're looking at, unmuzzling children and empowering youth to be able to have a say in their custody decisions and in the homes where they feel safest. But in practice, what I'm hearing from you is that it is complicated. I'm hearing from you that language around, the child has to be sufficiently mature or sufficiently intelligent, that is so vague that sometimes that wording is used to disqualify children who otherwise are perfectly capable of speaking to their home environments. As you're doing more research on Georgia, Jinie, what concerns or questions keep coming up for you?
I think the main question that's coming up for me is, what would be the next step? And, how do we further advocate for a change in the environment or a change in the way that children's voices are treated? And as you mentioned, Georgia is the most progressive in terms of these laws. And so how can we address other states, and how can we ensure that children are being heard? I think when we talk about, advocating for children, family court system is not often brought up, but I think raising awareness, talking about this more is really important. And I think a big question remaining is then, how do we change that environment? Because we already have that law saying that it's a right, but how do we really make it a right in practice? And I think that first of all goes off of people's experiences within the court system, because there's a big disconnect, between the law of the court system itself and how it plays out in practice. So how does it affect the people going through the court system, and what can we learn from them, and how do their stories influence the ways that we should see these laws and revise these laws?
I think that you raise a really good point about how these laws are worded and how they're actually being implemented in our court system. I'm really interested to see over the next few years, young people who have been raised under this family court system are now aging out, are turning 18 and are adults and are speaking out. And we're just starting to see like the first wave of kids who grew up under this system where they did not have a voice are finally finding their voice. So I'll be very interested to follow that as that develops. Jinie, before we get to community questions, I want to remind viewers that they can find more of your reporting on our newsletter, and our Instagram accounts are a really good place to start. Of course, you can find all of that at familycourtreport.org. Now, Jinie, we got some great questions from our Family Court Report community members about our project and the work that you are doing as our first reporting fellow. And for these questions, I love it, considering the reporting that you've been doing, that we turned to our youth community members. So let's shift, Jinie, to the big picture for a moment. Let's go to some of these questions. Jinie, we have a question from Annabelle. She's 20. She's in Seattle, and she asks, as a reporter, who is the intended audience for the Family Court Report? What do you think, Jinie?
And I think I'm going to start off by saying I really like this question because it really helps me to, tailor the reports that I do. I hope it reaches as many people as it can. Everyday people who may not necessarily have, a majoring in law or majoring in philosophy. My goal would be for anybody to approach and understand this um, and for it to start conversations in the community. Voting rights for youth is something that we often talk about, but I wish that the family court system and the youth voice inside this system is, something that is talked about in an equal level. So I think, in short, the audience is really youth, adults, or family members or loved ones, in the community. And I also want the family courts report to reach people who have been in the family court and kind of empower them to share their stories. I think that's another big goal and aspiration.
Jinie, when I was first dreaming about this project, I was first thinking about that it was really for protective parents that were enmeshed in the system and were looking for support and looking for resources and looking for a place to share their own stories. And as the family court report has grown, as you has come on board, I really see this project as not just speaking to protective parents and children who have been in the system, but also folks who are like, I didn't know anything about the family court system before this. And now I see all these avenues where there's all these opportunities for change and progress, and I want to get involved too. And it's been really heartening to me to see a sort of calling in that this project is doing. Jinie, this question is for you. This is from Danny. He is a Seattle professor, an activist, and pro bono lawyer. He asks, in what way do you see your role as a reporting fellow with the Family Court Report aligning with and furthering your future goals and aspirations?
Awesome. I actually think this is a great question because I don't want the system to be such that like you need a degree, a lot of money, a JD, everything, in order to understand, understand the issues of the law. I really want to do research. I really want to do stay in, go to law school. And so I think in a lot of ways it connects to a lot of my aspirations. I really want to, make law education accessible to everybody because we really need to recognize that there's so few who are actually practicing the law. But, everyday people, just because they don't understand the law doesn't mean that they aren't punishable by it. My future aspirations is really to help everyone understand the law, regardless of their background or income. And so that's kind of how the Family Court Report aligns with my future goals and aspirations.
Well, I'll just say the world is lucky to have you, Jinie, and the Family Court Report is lucky to have you. And yes, please, please, more access to the law is would be huge, would be transformative. This will be our last question that we have time for today. This is from an anonymous community member. They are 18 years old. They're in Seattle, and they ask, what aspects of family court reporting do you find most fulfilling or challenging?
Honestly, it's really hard to find or hear the voices of people who have been in the system. There are people who do, voice their experiences, but I do wish there was more people who feel empowered to do that. And the most fulfilling part is, I think, actually like raising awareness to these issues because you would imagine like children being at the center of a lot of families or, having experienced that family dynamic. I would imagine that they would have more power or voice in the family court system, but the fact that like they don't, and, this is um, when we talk about youth advocacy, again, it's not a very common topic. And so I think that's really fulfilling to bring light to this.
Jinie, as you talk about those challenges, it can be very challenging to sort of swim in the stories of folks who are struggling in our justice system, especially families, especially children. And I just want to note for you, for me, for anybody who is part of this work with us, that self-care is so important. And there's a whole network of support, and our Family Court Report community is there, but to reach out because it can be hard to do this work for sure. But it's so important, and we're so lucky to have you, Jinie. Jinie, and it looks like that is all the time that we have today. Thank you so much for joining me. It's been fascinating talking with you today.
Yeah, likewise, I'm so lucky to be a part of this amazing team, and it was lovely talking to you as well.
Jinie Chon is the Family Court Report's 2023 to 2024 Reporting Fellow. You can find Jinie's reporting along with our newsletter and ways to join our fight for safe families at familycourtreport.org. You can also find us on Instagram, Facebook, and Twitter. We're at FamCourtReport. I'm Kristin Leong. I'm the founder and executive editor of the Family Court Report. Thank you for joining us.